everyone, welcome to Crime in Court. My name is Heather, and this is an update in the DELPHI case. In the past week or so, there were multiple filings that took place, so instead of doing multiple videos, I'm just going to read them all in one, and then they'll all make sense cohesively, hopefully. All right, so we left off last time where Nicholas McClelland wrote the motion for an information here, like a hearing, basically to discover information regarding contemptuous conduct on behalf of Baldwin and Rosie, the attorneys that are representing Rick Allen in the DELPHI case. However, and after that, sorry, let me catch you back up. So after that, with that motion from Nick McClelland, the prosecutor in the case, the judge in the case, Judge Gull, gave a specific date. It'll say in here it was like February something, and then Brad Rosie couldn't attend. He was going to be out of town because the judge just set the date and didn't even ask for input from anybody. So she didn't know that he was out of town. And then she continued it to sometime in March. I think it's the 18th. So now we've got all these motions that have come after that. So she continued the hearing. It's supposed to be March something. And there have been attorneys that have submitted their appearance on behalf of Rosie and Baldwin, and this is the first one that we're going to talk about. This defendant's counsel's motion for summary denial of the state's verified information for contemptuous conduct. This was written by one of the attorneys that is representing Baldwin and Rosie, which is this gentleman here, Michael Osbrook, I think you say. I don't know. But he wrote a really good motion, and we're going to read through it. So this is to the Honorable Francis C. Gull, the special. Every time I hear that, I'm like a seagull, like a bird, the bird, seagull. Never mind. All right. So defendant's counsel's motion for summary denial. This was written, I believe, on the 12th. It was filed. It's not on here, but I believe it was filed with, there's another thing that we're going to read, which is a petition for clarification, which came out at the same time. So I think they came out on the same day. So let's begin. Counsel for the defendant, Richard Allen, Andrew Baldwin, and Bradley Rosie, by counsel, now come before the court with their motion for summary denial of the state's verified information for contemptuous conduct, or information. That's what they're calling it. It's kind of like a hearing where you're supposed to show that there was contemptuous conduct, like you're supposed to show discovery or whatever. I don't know, something like that. So for the reasons that follow, the court should summarily deny the state's information. The state's information has many flaws. Not least among them is its failure to allege, either directly or by inference, either Mr. Baldwin or Mr. Rosie committed any of the supposed offending acts willfully. And that word is key because it needed to be willful, and Nick McClelland has not in his, well, I'll let this guy pick apart Nick McClelland's motion for the information because he does a really good job of it. And it just, you need to have proven or have some kind of evidence that it was willful, that they did some kind of conduct that willfully disobeyed the court, which none of the things that they did amount to willful contemptuous conduct. But I'll let this guy tell you. So defining indirect contempt as willful disobedience of a court order. So that is what indirect contempt is. Willful disobedience of a court order. But in Nick McClelland's motion, he never distinguished if it was indirect or direct contempt. But the state's information has two additional flaws that are fatal. First, to the extent the state's information purports to allege indirect civil contempt, it fails to allege any act injuring the state that a remedial or coercive contempt sanction could redress. The state, therefore, lacks standing to pursue its information as one for indirect civil contempt, and this court lacks jurisdiction to consider it. So there isn't anything that the court could do to fix it because the leak or whatever has already been done. So it's not like there's something that can be done to address it or redress it, remedy it. So and because they can't do so, the court lacks jurisdiction then to even consider the motion. Secondly, because there is no available remedial or coercive contempt sanction, any contempt sanction would necessarily be punitive and therefore a finding of indirect criminal contempt. So he's saying the way that it is being presented, it needs to be filed more so as an indirect criminal contempt rather than just indirect contempt, or he didn't say in his thing, just contempt. All right, but to pursue indirect criminal contempt against Messrs. Baldwin and Rosie, the state would have to file its information in a separate case. It is not done so, and this court has no authority to punish Messrs. Baldwin and Rosie for indirect, to punish Messrs. Baldwin and Rosie for indirect contempt, criminal contempt for this criminal case against Allen. So this is Mr. Allen's case. This is the state's case against Mr. Allen. Nowhere in this state's case against Mr. Allen does the prosecution have jurisdiction to, or even the court have jurisdiction to punish the attorneys representing the client. So it would have to be a completely separate case. It would have to be a criminal case, he's saying, and they just didn't file it correctly. If that's what they wanted to do, it would have had to have been separate and criminal in order to get to the punishment that they were asking for, because they wanted fines put on them and jail time, potentially. You can believe that. So finally, were the court to impose without jurisdiction or authority to do so any necessarily punitive sanction on the state's information in this criminal case against Mr. Allen, it would be at least the second time that the court has interfered with Mr. Allen's 6th and 14th Amendment rights to counsel. So, where's the first? At least one other time. Oh, I missed I'll come back to that footnote. I missed it. For this footnote, at least one other time, of course, was when the court violated his rights. Sorry, I was trying to think of the word. So the one other time, of course, was when on October 12th, 2023, in an email, the court ordered Messrs. Baldwin and Rosie to stop their work on Mr. Allen's behalf for at least a week. State interference with counsel in violation of the 6th Amendment is structural error for which prejudice is presumed. So if that were to happen, you would presume. So if a court were to interfere with counsel, then you're to presume that there is some prejudice there or some bias on her end. All right, so that's according to whatever case this was. Government violates the right to effective, it was Weaver versus Massachusetts. It also says C. Strickland too. So government violates the right to effective assistance when it interferes in certain ways with the ability of counsel to make independent decisions about how to conduct the defense. And it really seems here, and that's Jetters versus United States. Jeters, I don't So I totally lost my train of thought. All right, so decisions on how to conduct their defense. So it really seems like Judge Gull doesn't believe ever since the Franks hearing motion was submitted and filed and put out there in the public, it seems like Gall has had a serious bias towards Richard Allen and the defense team. It really seems like she doesn't like the line or their strategy that they're going with, and the court is not at all to interfere, and that's what the Sixth Amendment is saying: the right to counsel, not having a court or anyone interfere with the way that their counsel is handling the case or strategizing their defense. You can't interfere with that. All right, so notwithstanding so-called Younger abstention, because it may well not apply. See generally Younger versus Harris, 1971. Further state interference with his lawyers could well compare Mr. Allen to seek federal habeas relief under 28 U.S.C. in the form of an injunction. Were Mr. Allen to prevail in that undertaking, a conditional writ of habeas corpus, though using more formal legal language, sorry, I had to continue to another page, would look something like: release Mr. Allen or leave his lawyers alone. But win or lose, federal court is not a railroad, citing Chief Justice Rush likely had in mind when she said at the hearing on the second original action involving this court in this case, "My concern is getting this case back on track," and that was from the hearing with the Supreme Court of Indiana on January 18th. Chief Justice Rush. And I think that's the end of that footnote. Yeah. Okay. So she is concerned about getting the case back on track. And this whole thing, this whole charade of this contemptuous conduct, which doesn't even come to the level of contempt, it is... Sorry, my thing is... Well, whoops, my light squeezing my... never mind. All right. So it doesn't even rise to contempt, but yet, they're pulling this charade, the sham of, filing this motion to have this hearing. It just further and further delays the case. When, Bradley and Rosie said that, or Baldwin and Rosie said that they were ready to go to trial in January, at the beginning of January, when the case was originally scheduled to go, and then she took them off the case. It went off the rails. 2 other attorneys were assigned, and then it was now postponed to an October date. But Baldwin and Rosie are back on, so I'm sure they're going to want to push the trial forward. But with all this rigmarole that Nicholas McClellan is having them do, it's just delaying. So that's where we're at. And it's annoying to me that we can't just get this going. All right, so where was it? Oh, that was the footnote number 2. Oh, let's go back to the first footnote that I missed. This is a written motion required by Indiana original law, which requires in relevant part no petition of a writ of mandamus or prohibition will be entertained unless the relator has raised the jurisdictional question by written motion which the trial court has denied or not ruled upon timely. The motion shall allege the absence of jurisdiction of the respondent court or the failure of the respondent court to act when it was under a duty. So again, talking about the jurisdiction and not, this court does not have jurisdiction to make these, to make any kind of sanctions for Baldwin and Rosie. Did I read that? Yes. Okay. So number 1, they now he's going to break down all the arguments. The state's information was not alleged an injury a civil contempt sanction can remedy. So again, it's just not something a sanction can fix because the leak happened and it wasn't, willfully, which you need to prove that it is. And yeah. All right, so the state therefore lacks standing to pursue its information as one for civil contempt, and this court lacks jurisdiction to consider it. A. The state's information attempts to allege Messrs. Baldwin and Rosie committed acts of indirect contempt. As a matter of law, almost older than dirt, there are two kinds of contempt, direct and indirect. Contempt of court generally involves disobedience of a court or court order that undermines the court's authority, justice, and dignity. That's citing State versus Heltzel. There are two kinds of contempt, direct contempt and indirect contempt. Indirect contempt, which is at issue in this case, involves those acts committed outside the presence of the court, which nevertheless tend to interrupt, obstruct, embarrass, or prevent the due administration of justice. Reynolds versus Reynolds. It should not be a matter of dispute that the state's information at least attempts to allege Messrs. Baldwin and Rosie committed indirect contempt. None of the acts the state's information alleges were contemptuous, occurred in the court's presence, or about which the court itself has knowledge. Regarding Nassar, I think, direct contempt depends on the judge possessing personal knowledge of the contemptuous act. Citing Hopping versus State. All right. Sanctions for indirect civil contempt must be remedial or coercive for the benefit of an aggrieved party. Sanctions for indirect criminal contempt are punitive. As a second matter of law, almost older than dirt, direct and indirect contempt each come in two varieties, civil and criminal. Sanctions for civil contempt are, quote, for the benefit of the party who has been injured or damaged by the failure of another to conform to the court order issued for the private benefit of the aggrieved party. So that's like if the crime scene photos were leaked and then the families somehow, it was like sent to the families or something, and then the families were trying to sue Baldwin and Rosie for or not necessarily sue, but they were coming after them saying, this has hurt us in some way and we want some kind of reparation, some kind of remedy for that. All these quotes from these other sources. So there's a lot of case law that backs this up. Sanctions for civil contempt also must be either remedial or coercive. Regarding AS, citing Doomling, State X Rel McMinn versus Gentry, the object of a civil contempt is the enforcement or protection of the rights of the complainant, and only a coercive or remedial judgment may be entered. Federal authority is no different. That's from Gompers versus Sears, Roebuck and Company. For civil contempt, the punishment is remedial and for the benefit of the complainant. Again, that's like what I said. If the family of the victims saw the photos and were upset that, saying like this has just devastated us and here's why and whatever. They'd have to have proof as to what the punishment should be for that. Like if they were suffering harm, emotional harm or whatever, they have to prove it. Anyways, all this other case law, again, backing up his argument. Criminal contempt, on the other hand, is, quote, an act directed against the dignity and authority of the court which obstructs the administration of justice and which tends to bring the court into disrepute or disrespect. So sanctions for criminal contempt are intended to vindicate the authority of a court, and this is many different cases that they are stating. Again, a lot of proof to back up his arguments here. So the state's information alleges no injury or civil contempt sanction can meaningful redress, and the state's resulting lack of standing to pursue its information means the court has no jurisdiction to consider it. Even were the court to take as true every allegation of the state's information, no sanction imposed for any of the alleged contemptuous acts would remedy an injury to the state, nor would it coerce Messrs. Baldwin or Rosie to comply with an order of the court the state's information alleges they violated. So it's not going to, there are no sanctions that will make the state feel right about it. And there are no sanctions that will keep Baldwin and Rosie from doing it again, because it was like a one-off thing and it was somebody that they trusted, and not even they, it was Baldwin. So Rosie has nothing to prove here. But it was Baldwin's office, Baldwin's associate consultant friend, who snuck behind his back and took pictures and then leaked them. So again, that's not willful. So I don't know what they're thinking, but it's, yeah. Anyways, let's keep moving on. All right, so governing indirect contempt, the court shall, on proper showing, extend the time provided under subsection B3 to give the defendant a reasonable and just opportunity to be purged of the contempt. Again, that's from Reynolds. Civil contempt orders avoid punishing the contemner by allowing the party to be purged of contempt. The state, therefore, has no standing to pursue its information. The standing requirement is a limit on the court's jurisdiction which restrains the judiciary to resolving real controversies in which the complaining party has a demonstrable injury. So you can't show what the injury is. That's coming from Schloss versus the City of Indiana, and Hames versus Brumley, and then Solarize Indiana Inc. versus Indiana Gas and Electric Company. Only those persons who have a personal stake in the outcome of the litigation and who show that they have suffered or were in immediate danger of suffering a direct injury as a result of the complaint of conduct will be found to have standing. Again, that's Indiana Department. The state Citadine versus Indiana Department of Transportation. Absent this showing, complainants may not invoke the jurisdiction of the court. So they haven't shown that they haven't shown the conduct was contemptuous, and therefore you can't even, or that there was anything suffered by the conduct. You haven't shown that, so you have no jurisdiction. Without an injury meaningfully redressable by a civil contempt sanction, the state simply does not have standing to pursue its information, and this court does not have jurisdiction to consider it. Because Miller did not have standing to bring his contempt motion, the trial court did not have jurisdiction and should have dismissed his motion. Accordingly, the court should summarily deny the state's information. Number 2, the state's information can only be seeking punitive sanctions for criminal contempt. The state filed it in the wrong place, and this court has no authority to impose a criminal sanction in this criminal case against Mr. Allen. Without an available remedial or coercive sanction, any sanction imposed by the court, whether imprisonment or a fine, would be punitive, thus making the object of the state's information a finding of indirect criminal contempt. As a third matter of law, almost older than dirt, a fixed sentence of imprisonment is punitive and criminal if it is imposed retrospectively for a completed act of disobedience such that the contemptor cannot avoid or abbreviate the confinement through later compliance. Bagwell. Similarly, a flat, unconditional fine totaling even as little as $50 announced after a finding of contempt is criminal if the contemptor has no subsequent opportunity to reduce or avoid the fine through compliance. You have to give them the opportunity to comply. An information for indirect criminal contempt must be filed in a separate criminal action. As a fourth matter, a law almost older than dirt, if the state, by its information, is seeking punitive sanctions for indirect criminal contempt, it filed its information in the wrong place. A proceeding for indirect criminal contempt must, quote, be filed as an indirect or independent action, and must also be prosecuted by the state, end quote. And that's from Allison versus State ex rel. Allison, and Thompson versus Thompson, and State versus Hetzel. In States versus Hetzel, William Hetzel and Mark Kiesling were charged with indirect contempt of court in an information filed by the Lake County prosecutor. A charge of criminal contempt should be prosecuted by the state against the defendant in an independent action. That's Denny versus State regarding Brady. The information for a criminal contempt should be entitled State of Indiana versus the defendant and filed as an independent action and prosecuted by the state. Again, just more proof that they didn't do it right. Jones versus State. In a separate action, the state charged Jones with indirect contempt under Indiana Code sanctions, whatever, for her failure to appear at the October 7th deposition. The court has no authority to impose any punitive sanction for indirect criminal contempt in this criminal case against Mr. Allen. The court simply may not impose any punitive sanction for what could only be a finding of criminal contempt in this criminal case against Mr. Allen. So it's a criminal case against Mr. Allen, and you have to file a separate criminal contempt case against the attorneys. It can't be on the same docket number, case number. That would amount to a conviction and punishment on a charge the state has not made. The situation would be no different from that in McMinn. McMinn was convicted on a charge that was not made, which is a sheer denial of due process. Exactly. So they're just denying due process all over the place in Delphi or Carroll County. Right, I think it's Carroll County. So see also Thornhill versus Alabama. Therefore, the judgment and commitment issued thereon are void. So you can't make a judgment. It's completely void and null now at this point, any judgment that was made, because the due process was not followed. Accordingly, for the second reason, oh wait, where did we have a footnote? There was a footnote here during this. The state charged Jones with indirect contempt when for her failure to appear on the 7th to court. So not only was the state's information filed in the wrong place, but as written, it also fails to make out a criminal charge. It does not allege Messrs. Baldwin and Rosie acted willfully, omitting a material element of indirect contempt. This is not remedied by any reference in the information, which denies indirect contempt as willful disobedience. So they have, again, just not they make these allegations, but they haven't proven that it's willful disobedience. So accordingly, for the second reason, the court should summarily deny the state's information. Conclusion: for the foregoing reasons, Messrs. Baldwin and Rosie respectfully request the court summarily deny the state's verified information for contemptuous conduct. And that was signed by Michael K. Osbrook from the Indiana University Maurer School of Law. And so it appears he is a professor. So that is a great argument as to why there should be no contempt of court. Then this was filed on the 12th as well that went with that summary. It says, petition for clarification regarding contempt hearing. Comes now attorneys Baldwin and Rosie by counsel and respectfully petition the court to provide clarification regarding the March 18th, so that's when the hearing is, contempt hearing. In support of their request, counsel state on January 29th, 2024, the state filed what is titled Verified Information of Contemptuous Conduct. On February 1st, 2024, the court set that pleading for a hearing of February 12th, 2024, which was then continued to March 18th, 2024. So now it just keeps getting longer and longer before Richard Allen starts to go to trial and we start to see justice for Abby and Libby. Attorneys Baldwin and Rosie are without sufficient notice as to the details of the state's allegations and how or why any specific acts are alleged to be contemptuous. So with the filing that Nick McClelland filed for the motion for information, he should have also provided discovery, reasons for the allegations. They need to have proof or backup. Why, what is the allegations and how does it fit into the term contemptuous conduct? Like, it has to legally meet that requirement. So at this point, Nick McClelland has not done that. So they're asking for clarification. The state has referenced the following with insufficiencies described. A, it refers to a press release issued prior to any gag order that was in place without specifying how or why that was contemptuous. So how is it contemptuous if you stated in a press release something about your client and there wasn't even a gag order in place? B, that Mr. Baldwin failed to disclose an accidentally misdirected email but cite no authority or order requiring disclosure. So was no reason to believe that he did anything wrong because you haven't cited why it's wrong. Reference the Frank's memorandum as having graphic descriptions and defense-created demonstrative exhibits, but failed to advise how that was contemptuous conduct. And you can't criticize or stop a defense team from going with a certain defense strategy, as we read in the other motion. All right, or response, I should say, I guess it was a motion to summarily deny. All right, so D, reference Mr. Westerman's unauthorized photographing of Discovery, but failed to allege how that was the fault of Mr. Baldwin or Mr. Rosie, or how it was willful conduct on their part. Exactly, it wasn't willful on their part because they didn't even know about it. Mr. Baldwin brainstorming with Westerman violating both. Oh yeah, it's the next page. Both orders, but ignore that in an in-chambers meeting, brainstorming and strategizing with person not on the defense team was declared permissible. So there's nothing wrong with talking your strategy. Excuse me, throat's dry. There's nothing wrong with talking your strategy out with someone who is not a lawyer or with other lawyers. There's nothing wrong with that, but for some reason they are citing that it's wrong because he was using Westerman as a consultant in the case. F. Allege a trend of Baldwin and Rosie not being completely honest, yet offer no details or cite to any authority or requirement to support the allegation. It seems clear that the state is really attempting to charge indirect criminal contempt. See defendant's motion for summary denial. As such, a separate filing and initial hearing would be contemplated. So they're supposed to have a separate filing, I guess. Or no, they are supposed to have a separate filing and a separate hearing. So outside of the Allen trial whatsoever. That's what he was referring to back to the summary denial. So attorneys Baldwin and Rosie respectfully request notice whether the March 18th hearing will be a formal advisement of specific allegations or whether the court anticipates hearing testimony and receiving evidence. And that was sent by David Hennessy. He's representing them, I believe, at the hearing. The Michael Osbrook, who wrote the defense, is I think he's just on the case, helping more so in the background and helping with the filings and things like that, and not necessarily the one that's going to be arguing for them in court. But anyway, so they have two separate attorneys, the David Hennessy and Michael Osbrook. So that was that regarding the contempt. What do you guys think? It's pretty interesting, huh? I thought it was some really good arguments. Even if you don't understand all of the legal arguments, which I don't understand at all, I can understand the sentiment behind it all and how well written and effective it should be, but we'll see what Gull does, because I don't have any faith in her or what she's going to do. So the next filing was the 14th, so 2 days later, the state of Indiana, Nick McClelland, files this. The state's notice and request for discovery cutoff date. So now comes the state of Indiana by its prosecuting attorney, Nicholas C. McClelland, and respectfully notifies the court that the state has turned over the discovery information that the state intends to use at the hearing on contemptuous conduct in compliance with Indiana Supreme Court Rules of Criminal Procedure Rule 2.5, previously Carroll County Local Court Rules, and in support states the following. That the state intends to call specific witnesses and introduce various pieces of evidence at the hearing on contemptuous conduct scheduled for March 18th. So they do intend to call specific witnesses and introduce evidence. So they are going to be, there is going to be argument on the 18th of March then. So that kind of answers that. 2, that per the local rules and the Indiana rules in criminal procedure, the state of Indiana has turned over the list of witnesses and the list of exhibits to the defense. That the state sent a separate document entitled Witness and Exhibit List to the defense, along with a link that allows them to download the exhibits. So they're just putting it on the record. We sent you all this stuff. 3, that the state believes the defense intends to introduce affidavits and other exhibits along with testimony from various witnesses at the hearing. So they are expecting the defense to make a rebuttal argument and provide, evidence. So number 4, the state would ask that the court issue an order commanding the defense to turn over all evidence by 5 p.m. Thursday, March 7th. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClelland, puts the court on notice that the state has turned over all the discovery that intends to use at the hearing on March 18th, along with a list of witnesses and that it intends to call. The state would further request that the defense be ordered to produce all their discovery and witness list for said hearing by end of business on Thursday, March 7th, in order to give the state adequate time to prepare for the hearing. So that's filed by Nicholas C. McClelland, and that was on the, what day did I say it was? The 14th. So 2 days after Baldwin and Rosie's filings come out, then Nicholas McClelland responded. So now we get an idea that, okay, they are going to have to put on an argument. It is going to be a hearing where they're going to have to show evidence and argue their case. So now they know how prepared they need to be for this hearing. The only other thing that I wanted to say is, why do they need the discovery from the defense? And I was listening to the Defense Diaries. Bob Mata did an episode. He read through some of this stuff too recently, and he was saying that in Illinois, you don't have to give, if you're the defendant, you don't have to give your discovery over to the prosecution. But he doesn't know if it's the same in Indiana. So why is Nick asking for the discovery of the defense? They shouldn't be required to hand over their discovery. I mean, maybe, yeah, their list of witnesses and whatnot, they have to, things required by the court, but not necessarily their discovery. So I don't know if they're like really seeking something or trying to intervene with their strategy again. They keep trying to intervene with the defense strategy and intercept it, I guess, and figure out what it is. So there's that. So is this in response? No. To Nicholas McClelland. Yes. Well, this happened late on Friday, so this was kind of exciting. Late Friday afternoon. So anyways, notice of depositions by non-stenographic means. So there's not going to be a stenographer, but probably recorded depositions is what that means. So please take note. This is from Richard Allen's team. Please take notice that on Friday, March 1st, 2024 at 9 a.m., the counsel for the defense attorneys regarding allegations of contemptuous conduct by the prosecutor will take the depositions of Sergeant Jerry Holman, and we've heard that name in all of the DELPHI stuff with involving the investigation and whatnot. So they are doing depots of Jerry Holman, Detective Ben Rector, Mr. Steve Mullen, and Mr. Mitch Westerman, the man, the myth, the legend who actually did steal the photos and caused this whole huge debacle with the leak. So he is, so they are doing depositions on all 4 of these individuals. These depositions will be taken by non-stenographic means remotely or in person at a Carroll County prosecutor's office in Delphi or other location as required by state or statute. Said depositions are to be taken in connection with the above captioned cause. So the above captioned cause. The oral arguments shall continue from day to day until completed. A subpoena duces tecums for the deponents are attached here too. You are invited to attend and cross-examine. So they are telling, this is done by David Hennessy. So they are saying, we're doing these subpoenas. You guys are invited to attend and cross-examine too if you would like to, not subpoenas, if you would like to do a depo on these 4 individuals. We're doing them on this date and time, and you're welcome to come along for the ride. So that's kind of what they're saying here, and that's the end of these filings. So I'm really interested to see what Gull's going to say in response to the defense to summarily deny the case altogether. What do you think about that? What do you think Gull's going to do for the regarding this denying the contemptuous conduct, or do you think she's going to continue to go forward? It's funny too because this came out prior to McLeland's filing, but so he's had a chance to like address all the things that have been wrong with his motion for an information, r- rather than coming back with this. I don't know, this statement or this motion. I mean, petition for clarification. Oh no, that was them. Sorry. Nick McLeland came out with this, the state's notice and request for discovery. So he came out with that instead of, addressing the issues that he had going on with the issues that Michael what was his name? Ockbrook? Gosh darn it, I don't remember now. My brain, see how my brain just like Osbrook. Okay, I think I was right. I don't know. My brain just is like, wait, no, was I right? I can't hold on to details for very long, which makes things hard to do here. But anyways, so yeah, so his I'm curious to see what uh-oh, my battery's gonna die. Don't die, don't die. Whoops, I forgot I was not plugged in. So anyways, that is pretty much it. I just wanted to give you guys an update since there were so many motions that came out this week, and I didn't even know of some of them until after the fact. So it was kind of like a ripple effect. All these just came out. So I was like, I'll just do one big video and get them out there to you guys, and then we can talk about it. So let me know in the comments below what you think. Please don't forget to like this video and give my channel a subscribe if you like to hear about the Delphi case. Or I'm also going to dive into not Indiana, I'm sorry, Idaho 4. But there just really hasn't been a whole lot right now, and so many creators are doing Idaho 4, so I'm not gonna like just get into it for nothing. I want to do the document readings and whatnot. So there have been like little ones here and there, but nothing really major. So if something major comes out with Idaho 4, I will let you guys know also. So don't forget to subscribe for that. And thank you so much for watching. Take care.